Hello, welcome to the Express Notes ACCA paper F4. This is the global variation of this paper, so do be careful on ACCA websites that you don't pick up the UK or any other country's variation of this paper. There are more than one ACCA F4 paper. This is corporate and business law, and as I say, it's the global version. The express notes are, as they say on the tin, it's an express note. It's not the detailed notes. They're not meant to cover everything, and that is an important point. We will, however, cover these 10 chapters. They're on the screen, ranging from different legal systems, international organisations, commercial arbitration, contracts, international sale of goods. We'll look at agencies and how they work, partnerships, then we're going to form companies and their finance, but unfortunately companies go into administration and liquidation. Those are covered in later chapters, finally finishing on a slightly high note of a fraudulent behaviour and the law around that area. So quite a lot of chapters. I will do one video, one recording, no more than 10 minutes, some will be shorter, covering each chapter. So we will get through the syllabus. But like I say up front, these express notes are not meant to cover everything on the syllabus. Okay, that's important. They will go through most of the key points, but not the whole syllabus. Okay, chapter 1, different legal systems. What are the different legal systems? Well, they are three main ones that we're going to look at. They're called the common law, which is something that's set out in the UK, civil law, which is something that operates within France, and Sharia law, which operates within countries like Iran. Questions in this area tend to be the compare and contrast type approach. In other words, looking at common law versus civil law, or civil law versus Sharia law. That's how they tend to operate in this area. And although you're doing the global variant of the paper, it's worth bearing in mind the examiner is UK based, and therefore it does tend to be more UK biased towards this, even though it's a global paper. This tends to be UK bias. We will look in more detail at the common law versus civil law approach. Basically, however, just to summarise, the common law was set up in medieval times, looking at what was the common law of the country and trying to decide what was best. What did the common people do in their villages up and down the UK? And then judges would then interpret and make up the law as they saw best based on their experience. Civil law, however, enshrines law in the country and judges have to follow it, but we'll talk about that later in this chapter. What I would say at this point is, as it shows on the notes, another question that's very common in this area is the role of judges. Judges have a much bigger role in common law than they do in civil law, and it's something called the concept of judicial precedence. In other words, once a judge has interpreted a decision, if they are in a higher court, then all lower courts must follow that decision, whether they like it or not. That's the way it goes in the common law system. What is also apparent in this area is questions sometimes possibly to confuse you, but they sometimes look at the legal proceedings under criminal law as opposed to civil law. Now, this civil law is not the same as this civil law. Okay, it is not the same. This civil law in this picture is the type of law of the land. This is a procedure whereby in a civil case you have a person, claimant, taking on a defendant, another person. So you have someone's surname versus another surname, is an individual. Criminal law is the state, in the form of the Crown Prosecution Service, taking on the accused. So somebody who's robbed a bank, say, is the person being accused, and the government will take them on at court. Okay? And it's the defendant who's in this position, and the claimant is in this position. Okay? Notice, however, also another difference is beyond reasonable doubt is far more onerous than the balance of probabilities. So in a civil case, it's less onerous to get a conviction. Depending on the serious nature of the case, will determine where it's heard. In a criminal case, in a civil case, it is always heard by a judge. Judicial precedence is an important term. It is only associated with common law systems, and it's allowed because in such systems judges are able to create law by making their decisions on each case merits, if you like, because what they do is they apply their knowledge and interpretation of the law to make a decision, which, if they're a high court or lower courts, must follow. Positive thing about that is it means that there's hopefully a high consistency in your law, because lower ones must follow higher ones. So that's hopefully good. It hopefully positively means that law is done quickly as well. Instead of having to go through Parliament to create new law, a judge can be influenced by what he's reading and hearing and whatever in how to decide a case a certain way. That's an advantage, but of course there are disadvantages. When a judge from a lower court is trying to decide whether to follow the higher court, they will have to consider whether the facts are materially the same, and therefore if it is, they then can follow the higher court in their decision, but only if. What's a common law? As I say, primarily associated with the UK because of our historical influence. Other countries have followed, most notably the USA. It's the common law of the land and trying to create equity within the system for people. You have the law created by Parliament, and you have also EU law, which also comes into the country, and cases are written and heard. Slight difference between the USA and the UK is that the US have a written constitution, which also influences how judges interpret the law. Civil law is called a system where you tend to use codification. In other words, you have your legislation and you must follow the law as given by the Parliament, the people who create the law. An advantage is that it brings understanding and certainty. In other words, you haven't got the whim of a judge in how they interpret the law as written. So there is an advantage there. Where do they get the source of their law? Well, it's in their constitution. Obviously, what Parliament creates at statutory level. They have also in France administrative regulations, and they also again have EU law. So it's the same as the UK. Key point, as I've already pointed out, is that in a civil law system, the role of judges is simply to apply the law, not to interpret and make up their decision from their interpretation and knowledge. So therefore there is much less guidance and no formalised system of judicial precedent. So a lower court doesn't have to follow a higher court. They can interpret the law as they see it, by applying it. So that's the difference between the civil and common law. And I say in this area is a compare and contrast type of scenario, often in the exam. Okay, that's the end of chapter 1. I'll see you in chapter 2.